That's different than an accused pushing out their view of what happened here in a way that potentially impacts the administration of justice.
Alex here, just with a quick summary. Brittany ended up having some issues with the camera that made her about 5 minutes late. Unfortunately, she was not able to set the camera up until there was a break in the proceedings, so she ended up missing a full hour. But there was a second hour and about 15 minutes that was recorded. The first hour basically went over the competency evaluations and psychological reports / evaluations. There was disagreement from both sides, both Roger Hillygus and the state, but it didn't end up being something that came to a resolution anyway. District Court Judge Barry Breslow ended up having to set up another hearing on that's coming up in the future, which hopefully there will not be any issues with, and we will actually be able to record. There were several other motions that were addressed in court, and fortunately, we were able to record that portion of the proceeding, and so let's go ahead and get started.
All rise. This court is again in session.
Thank you. Please be seated, everyone. All right, we're back on the record in Mr. Hillygus and Mr. Handte's case. We're at the point of the proceedings where the state has made argument as to why it believes Mr. Handte has violated a previous order of the court, and either bail should be revoked and he should be remanded to custody of the sheriff pending the trial in this matter, or alternatively, the court should find him in civil contempt, and then we can move forward with those proceedings. Let me, before I hear from the defense in response to that, observe this with respect to civil contempt. The court reviewed Nevada Revised Statute Chapter 22, again on civil contempts. And in the event the court were to find that conduct that the state had made an argument, a persuasive argument, to set this for a hearing, a trial, mini trial, on whether contempt occurred, because the alleged contempt having occurred outside the actual physical presence of the court. The way I read the statute is, unless parties agree that this court would preside over the contempt hearing, either side could insist that a different judge hear the contempt proceeding. If the alleged contemptuous conduct occurred in the presence of the court can immediately, summarily address that action. If the alleged contempt occurs outside the presence of the court, the process appears to be on affidavit of the state. After setting a hearing, the judicial officer determines if a contempt occurred and what the proper remedy is. Unless parties agree to the current sitting judge to preside over said hearing, they have the option of directing the presiding judge to refer to a different judge to hear the contempt proceedings. That's the way I read the law. If you have a different understanding, please tell me. So first of all, Mr. Silverberg, has action occurred here warranting, in your view, a bail be revoked? If not, why not? And if you believe that the state has made a case to have a contempt hearing, what's your position on that? Plus any other issue raised by the discussion we just had.
Thank you, Your Honor. The short answer is no. I don't believe that anything has happened here that would warrant the very extreme that the state requests, or frankly any remedy. And here's why, Your Honor. Gag orders, as I stated, and as Your Honor also recognizes, are to be very narrowly construed. And the problem with that, and I'm just looking back at specifically the writ of habeas corpus filed by the previous counsel that lays out everything that happened at the preliminary hearing and a series of arguments, and basically laid out the defense for Mr. Handte in that case. And it's a matter of public record. Anybody can access this. Court open record, it's not sealed. You can come to the clerk, they can request a copy of it and see what the defense is in this case. And
Well, that's true of any criminal justice matter for which it proceeds through a preliminary hearing, right?
Certainly.
But that's different than an accused pushing out their view of what happened here in a way that potentially impacts the administration of justice, the jury panel, witnesses, things like that, right?
Well, first of all, I think that the state in that regard overstates the reach of this case as far as media attention. I certainly knew nothing about it. I watch the news all the time, but I didn't know anything about it until I was appointed on the case. There is a small group of people who are actively watching this, and they have every right to. And I think that while Mr. Handte's speech walks up to the line, and I agree that it does, I don't think he's crossed that line.
You didn't talk about the merits of the case?
Nothing that's not already a matter of public record.
Well, my order doesn't say that. My order doesn't say you can, talk about things that are part of the record. It says you're not to talk about the substantive position, your view of what happened here, why it wasn't a criminal act or conduct.
Well, and there is the problem with the gag order, because he's being prevented, I guess, from talking about something affecting his life in a very serious way that is on paper, public record. So how can anything he says be any more public than what's already in a matter of
That's what
public
trials
record?
are for, right? Trials are for the jury, hopefully untainted by things they've heard, read, or been told, to come in with an open mind and fairly adjudicate the facts and apply the law the court gives them. And when we have people, that's why gag orders are rare. They're rare. This was not an easy decision for the court. I had to go back and look at the authority, balancing First Amendment with the right of both sides to have a fair trial. Tried to craft what I thought was a reasonable approach that took into account all the interests here. But then I have somebody who, according to the state at least, knowingly violated that not once but 5 times, and then got close to the line and didn't go across it this morning. And I certainly concede that whatever Mr. Stege brought to the court's attention this morning isn't the same as doing a 2-hour interview with a whole recitation of your view of how things went down. But still, sure, are there problems with gag orders? The answer is sure, agreed. That's why they're rarely entered. But they're entered in cases that, in the court's estimation, deserve them, and they expect to be followed.
Certainly understand that, but I also understand the difficulty in interpreting and understanding where that line is for somebody who has put things through his lawyer on paper to talk about his defense, and why he all of a sudden shouldn't be allowed to talk about that. So if he's crossed that line, I would say it is barely. Is his language inflammatory at times? Certainly. Am I happy when I read things or hear things about his views of people that I know and respect? I'm not happy about it, but I recognize that it is absolute right to have those feelings. I think much of what the state brings up is clearly outside of the gag order.
One more thought, sorry to interrupt you.
No, please.
One more thought. This hearing is a bit unique in that ordinarily, the state would file an affidavit saying we think there's been a violation of your court order, set it for a hearing before your honor on whether there's been a civil contempt. Or if parties don't agree with presiding judge, somebody else. And if that's all it was, I wouldn't even be hearing this argument right now. I would only be deciding whether I would hear it or a different judge. But we're tied at the waist with a contemporaneous motion to revoke bail, which necessitates argument on the merits, the same types of argument on the merits that will be made if the court declines to revoke bail and just sets it for a contempt hearing. So I want everyone to understand procedurally where we are. I'm hearing the bail revocation argument. If you want to speak to the contempt issue, again, without waiving your right to ask for a different judge, if you decide that's the way you want to go, or you can stipulate that this is that hearing, you have the authority to do that if you so wish. There's a couple different things going on all at the same time, okay? So I'm asking you right now about the bail. Obviously, relates to the concern the court has that there might have been contempt involved civilly. Here you go.
Thank you, Judge. And I'm not sure that changes anything that I have said or going to
No,
say.
it doesn't. It doesn't.
Bail should not be revoked in this matter. Mr. Handte appears at every hearing before this court and conducts himself professionally before this court. He sits here, he listens. I know he's chomping at the bit, but he handles himself appropriately in front of this court. He has a right to talk about things that upset him and things that he finds are unjust in the system. And I think much of what is brought up by the state is just that. I find the court system to be corrupt. I find there's a lot of corrupt law enforcement officials. I think the DA's office is corrupt. I don't share those views, but I respect his ability to voice them. Those don't go to the merits of the case, but I think it really does bug the state when those things happen. When Mr. Handte makes a police report against Mr. Stege, I'm sure that really gets him upset. And I think that colors his pleadings, and I think it leads to the overreach of the remedy that he is seeking here today. And it is, it's an incredibly extreme remedy for somebody who's not breaking any laws, who's appearing at every hearing, who's checking in with pretrial services. Now, Your Honor has said, I don't want you to have any more contact with Mr. Hillygus. He's gonna honor that. If he doesn't honor that, it's a direct violation of the court's order. But until today, that wasn't the order. It was while he was in warrant status. I guess the other thing, that I hear this recurring theme from the state that somehow, because Mr. Handte's in law enforcement, he's very sophisticated and understands legal pleadings and all that. And that's just not the case. He's not trained as an attorney. There's a difference. He is former law enforcement and has a decorated career in law enforcement. I know Mr. Handte from my private practice, where he stood up for people in an honorable way.
He did acknowledge at least twice during, 2 of these 5 events that he was aware he either was violating the court's gag order or believed he might be or didn't care. And that shows a certain insight as to your conduct that I don't often see when somebody's being accused of violating the court order.
Well, and I understand that, Your Honor, but I think he does want to walk it right up to the line. I think he is doing exactly that because it's his right to do so. It's his right to do so under the First Amendment, to walk it right up to that line. And I don't think that he has gone way over that line any more than anything that's already in pleadings for the public to see. I think the appropriate remedy is to admonish Mr. Handte about exactly what is expected and what is allowed. Maybe put a suspended week-long cool-down period over his head if there's another violation. But this man has First Amendment rights to talk about a lot of things that don't violate the court's order, that none of us like. Nobody wants to hear it. But that's the test of the First Amendment. That is the actual test.
Mr. Stege's going to say these are arguments that were made by his counsel at the time that this order was entered, and persuaded the court to moderate its gag order. But we're beyond that now. We're beyond it. We're now at the point of, was the order materially violated?
Right.
It was not.
I believe he's walked it right up to that line, and due to his method of articulating his feelings, it's easy to say, oh, he's gone way over the line. But it's more the method of his speech as opposed to actually crossing that line in a way that doesn't just generally speak about the defense in this case, but saying that there's guardianship abuse. I know nothing, this is all eye-opening to me, but there's at least a group of people who believe that that's a real issue. And he can talk about that and believe that violates the court's order. He can, as I put in my opposition, he can have opinions about me, about Your Honor, about Mr. Stege. He can have harsh opinions, and I've dealt with them personally. the opinions he has about me at times. He can have those opinions without violating the court's order here, but it's hard to separate. And I think that's the challenge here, is it's hard to separate his manner of speech with the actual content of it. And I don't think if he's crossed that line, I think it's very slight.
Certainly not enough to warrant revocation of bail.
Absolutely not. I think that would be an extreme and unwarranted remedy for somebody who appears at every hearing and conducts himself respectfully to this court while these proceedings are going on, and who's in compliance with pretrial services, who's working every day, but I hear this about flight risk and how to, I'll just tie in the GPS briefly and how, you know, it's working and it's kept him here. His life is here. He's not going anywhere. And the GPS
Let me pause there. He was heading to Elko when he wasn't supposed to, I think. Then he was heading to Eureka at a time he wasn't supposed to, and he had blown off the court order to put on the GPS unit the first time. And before all that happened, he was dropping by people that were potential witnesses to let them know that he was around. I mean, there's a backstory here as to why he's wearing the GPS in the first case. And so it's going to be a hard sell to the court that should be modified, you know, other than, you know, extreme hardship, which I'm not sure I'm seeing here. But I'll give you a moment to confer with the client. Looks like he wants you to touch it.
Thank you.
Okay.
Again, everything that Your Honor mentioned as far as if he's going up and talking to people that he shouldn't talk to, or going places he shouldn't go, the GPS is not going to prevent that. Cell phone tracking, which the state apparently has a dump from Mr. Hante's cell phone. There's other ways to do this, and I don't believe he was aware of any travel restrictions within the state. To the extent there are, I mean, that needs to be made clear, but I don't think GPS is really preventing him. That's not what's keeping him here. And it's not preventing him from having to answer to this court the state's motion that he somehow violated a gag order. Seems to be the state's more urgent concern today. Again, I don't want to be repetitive here, Your Honor. I don't think that he's violated the order. I think everything he's talked about is well within the confines of documents filed in this proceeding that the public has access to if they're interested in it. If they're interested in it, and I don't know that they are. There's a small group of people that are definitely very interested in guardianship and guardianship cases. But he can speak to that. Other than that, Your Honor, I just don't think that full-on revocation, certainly full revocation of somebody's bail under the facts of these cases is not warranted. And given the nature of his speech and what's gone on up to this point, I think what Your Honor should do is admonish Mr. Handte about his conduct to the extent Your Honor thinks that he's clearly crossed that line. And if there's other issues, I can't get up here and say he wasn't on notice of exactly what was expected of him. And say, if this happens again, or I'm going to impose a temporary cool down, but I'm going to suspend it. But just so you know, I, Judge Breslow, am serious about what I'm saying right now. And you know, there's a line where you can say everything you want. You can talk about me, you can talk about the DA, the judge, the police, as long as it's not specific to their conduct in this case. But to generally have the opinion that law enforcement suffers from corruption sometimes, that the DA's office, and I'm not saying I agree with that. I'm saying he has the right to say it, and it's not violating this court's gag order.
All right, I understand the defense position. Mr. Stege, you may respond.
That's an argument that someone who hasn't listened to his interviews. No one is quarreling with his ability to have opinions about the criminal justice system. We can sit here and play these interviews for Mr. Silverberg and Mr. Handte, where he relates, as the court says, I thought there was abuses. Here's where I met Mr. Hillygus. Here's where we went, I talked to Oliver Miller. Here's where we went inside the place. Here's where we did this and that and that. That is explicitly prohibited by this. And so,
Here's where Roger signed his name Gus, because he's known by Gus.
Yeah.
Here's why
yes,
he signed Susie, because she likes to consider, at that time, instead of Susan, it's sort of a younger way of
Yeah.
identifying herself.
yes, that is in direct violation of this court's order. Now, I understand why someone would sort of make the First Amendment argument, because it's very, we all agree in the First Amendment. It's a very important right. No one is against the First Amendment.
I have it right here,
Yes.
and I have I think I may have told you this, I have a United States flag of a fallen soldier right here, a friend of mine,
Yes.
kid.
Yes.
And I remind myself why it's important that we live in a country like this and honor the
Yes.
laws that apply.
I agree with all that. But again, directly not addressed is Hante's repeat. I quote Stewart Handte, "I believe I'm violating the gag order right now and I don't care." He does not care. A symbolic finger wagging in court today will not change his behavior if we look at everything in the past. Confused the argument of whether he could be the state. The court was referring to he didn't show up for his GPS, he was fleeing, was pulled over and told the trooper that he was headed to the East Coast. That is what the court was referring to. There must be a remedy for this. There has to be a remedy for this for 5 times doing it. The argument that it's.
A remedy over and above finger wagging.
Yes,
Reminding.
I mean, I, that may be some strong language, but should he walk out of here with no remedy, that is, in effect, no remedy, right? A delayed remedy is no remedy, because even up until yesterday, still, knowing, it's clear throughout this record, he does not care. The argument that, well, it's this sort of, shucks, he's kind of a bumpkin, is a non-starter. A non-starter. The court has been very clear, the court was very clear, he has had among the finest defenders in this state defend him, and the idea that
As he does now as well.
as he doesn't, yes. Yes, this sort of, he can't be expected to understand something like this, that makes no sense. And nowhere in the law is there a proposition that, because it's in the record, he can go on and talk about it. It's already it's already known to everybody. The rationale for this, for having a gag order, is the same rationale that lawyers can't go out and say, hey, well, since it's already in the record, we had a preliminary hearing, let me tell you, folks, here's what this witness testified and that witness testified about, and by the way, it's not in the record. It's not evidence that Mr. Handte is talking about. It's trying to push out a counter narrative to what is in the factual record, the preliminary hearing, which we don't want. Again, don't care about his opinions about anybody. I have the bail condition where he's supposed to stay away from people, which he didn't, there's evidence he did. But we have a gag order that he not poison. And the irony should not be lost on the court that he wants to change venue when he's engaging in a media campaign.
Well, that's a factor in court to use, even if the jury showed up and said, yes, we've heard about the case, how come? Because we heard it from Mr. Handte or somebody
Right.
at his direction.
Right.
That works against the venue change right there.
Yeah, again, we don't care about that there's people who have opinions about guardianship, anything like that. We care, and the court cares whether he is out there talking substantively about the case. It is clear in the record he is talking substantively about the case. He knows there's a gag order. He says he does not care.
You didn't speak directly to the GPS. I'm assuming your position is, well, I read your brief. Don't remove it. No.
Don't remove it, there's no evidence for it. I guess once he had contact dermatitis, that was months ago. I've spoken with a GPS officer today, no further issues or complaints of that so far, or since then. You know, we make decisions on evidence, that's not evidence. Oh, he'd really like it off, yeah, I bet. But it's working. It's working. We have, because of the behavior he's engaged in, we must know where he is. We must make sure that he stays in the state. We must make sure he's staying away from the people and the parties in the case, which he is involved in this campaign, to call them, you know, to engage in a media campaign against. It is clearly working. Put another way, if the court were to craft an order today removing GPS, I don't know what evidence it would rely on. In September, the man had, when the doctors know in September he had contact dermatitis, full stop. That's about all the court could say right now. No change in circumstance. In fact, what today has pointed out is that it's even more necessary than it has ever been.
All right, thank you. I understand your position. The court finds as follows. Has there been a violation of the condition of bail? Yes. Does it arise to a level that the court is going to revoke Mr. Handte's status? It does not. Does the court believe that it's persuaded that the GPS monitor is no longer needed? No. Remains on as it has been. Additional conditions of Mr. Handte's pretrial release are that until Mr. Hillygus is adjudicated competent to proceed, he's to have no further direct or indirect contact with him. The court does not find civil contempt for the reasons I alluded to a little while ago. It was not done in the court's presence. My reading of the statute is, I need a separate hearing. And I need consent that this court may preside. Now, were I presiding and we're in this court, based on what I know and what's been produced and the argument, what I've listened to, very probably there would be. What would the remedy be? Probably something like a week in jail. Not 25 days, not 25 days times 5, a week. Now, I'm not going to pressure anybody to agree to any of that, but here's what I'm going to do. I'm going to leave the bench in a moment and come back 15 minutes later. I'm going to encourage Mr. Stege and Mr. Silverberg to speak on this issue, because option one is you are directed to another judge to have a hearing on the contempt, and he or she will decide if they found a contempt, and he or she will decide what the remedy would be, up to and including the full amount allowed under Nevada law, which is 25 days, right, Mr. Stege?
Yes.
Per occurrence. Could be 125 days in jail as a punishment. Or, I'm trying to telegraph how the court would view this. Serious? Yes. Should it continue? No. Is punishment proper? Yes, but as to the extent the court just identified. Now, you know, I'm not trying to unduly twist anybody's arm here to accept that you have this court preside and you accept this likely result. That's not the court's intention. The court's intention is to say, we can decide this right now if you want the court to. If not, I'm going to direct it to another judge unless you have me reset it for hearing. We make some of the same arguments again and play the audio and the detail that the state wants everyone to hear. So that issue will be decided definitively in about 10 or 15 minutes. The other issues I just decided. Bail is not revoked, no direct or indirect contact with Mr. Hillygus. GPS stays on. We have a date for competency hearing for Mr. Hillygus. We have a briefing schedule on what order, if any, on gag order for Mr. Hillygus should apply, pending the competency determination. That's on an expedited basis. We have a briefing schedule for supplemental briefing on motions that are outstanding that the court will take a look at later in the spring. We'll be in recess until 10 minutes after 11.
Thank you, Your Honor.
All rise. All rise. This court is again in session.
Thank you. Please be seated. Okay, we're back on the record. Reviewed the statute again, NRS 22. The defendant alone has the right to object to this court presiding over a hearing with respect to a civil contempt. The state apparently does not. So I'm going to ask the defense, would you like the court to move forward at this time? And if you say a polite no thank you, I will not be offended, and we'll direct you to a different department to have a hearing and let them decide whether contempt has occurred, and if so, what the remedy should be. Mr. Silverberg.
Thank you, Your Honor. I don't have a simple yes or no. What I have is a proposal where Mr. Handte would agree to be 1 week in county jail as a result of his conduct, and but would request that he be allowed to do that on weekends so he doesn't lose his job. And under those conditions, we would be certainly willing to go forward. And I think the good thing about dragging it out is weekends, certainly he doesn't lose his job, which is good, but it serves as a little bit longer of a reminder to stay in line. I think if he has to spend the next 2 to 3 weekends in custody.
These type of things are not normally subject to negotiations. This is a unique circumstance. So what I'm hearing is...
I don't see how they could be.
Go ahead.
I don't see how they could be the subject of negotiation. He's either admitting he's in contempt or he's denying.
What I'm getting is they're prepared to admit in contempt, waive the right to have a different judge and additional process, and asking the court to, for purposes of argument on what a fair punishment should be, that the 7 days be served over the weekends. Should I have that right, Mr.
Yes,
Silverberg? All right. Mr. Stege, they waive the right to have a different judge here, admitting the contempt. What's the state's position on what the court should do? I've given you my preliminary thoughts, but you certainly have the right to be heard. And I'm well aware that you wanted revocation of bail. I'm well aware the state believes that a civil contempt punishment should look a lot more like 25 days, and it should look a lot more like per violation, of which you've documented 5. I get
Right.
that.
Yeah, documented 5, and I'm getting no relief for the violation of the no contact order. So I understand, right, the universe is 25 times 5, but I have a difficult time understanding the math coming down to 7 days and the negotiation for weekends only. Ours is a court of law, right? Court orders, I always argue and always believe, have to have meaning. Just like bail orders have meaning, and there's sort of a moral hazard where defendants understand there's little risk in disobeying them, or in this instance, the mental state of flaunting them. So to me, thank you for the admission that he is in contempt. 7 days in the state's estimation is insufficient. Understanding where the court mind is at, I would go for 25 days. And the question of weekends, I don't, Mr. Hillygus, Mr. Handte.
I've done that before. I can tell you this, it's rare. The jail does not like that. There's a lot of processing in and out. There's a lot of sort of disruption, but But I've done it in the right circumstances for similar reasons, so.
Well, and I wouldn't in this case, because bare minimum of having a job is something you're supposed to do. Mr. Handte has always been able to come back to the same job. And in that same vein of this court meaning what it says, weekends is not in the state's estimation appropriate. So I ask in conclusion, 25 days for contempt for this, all 5 of them together, plus the violation of the no contact order to be served immediately. On the bail, I would ask the court to consider, there's a lot of mention of Ms. Stone in this, and sort of the architect of some of these mailers that are continuing to everybody that he asked for no contact with her, but I submit.
Would you like to be heard on the Ms. Stone issue? That's the first we're hearing of it right now. Okay, its order of the court as follows. The court does find Mr. Handte in violation of the court's prior gag order filed March 4th, 2022. Because and the court finds him in civil contempt. Because it was not done in front of the court, Mr. Handte has a right to a hearing, and if insisted with a different judge. Defense is conceding there's been a violation and consenting to this court proceeding. The court has heard argument. It's an order of the court then that Mr. Handte, you serve 4 weekends starting this Saturday at the Westchester County Jail. I want you there no later than 9 a.m. on Saturday, no earlier than 5 p.m. on Sunday. That'll count as 1 weekend. Do that 4 consecutive weekends, then we're good.
Thank you, Your Honor.
Please don't violate the court order. Don't get close to the line, which the court finds you were over, right? But don't even get close, because then you set yourself up to have a potential bail revocation hearing. The court does order, you have no contact with Ms. Stone, directly or indirectly. And I think that's all the court has for this afternoon. Mr. Stege, anything else before we adjourn this hearing?
No, thank you.
Anything else from the Mr. Handte side?
Could you clarify, Your Honor, no later than 9 a.m. this Saturday?
Yes?
Thank you. Got it. And then he'll go till 5 p.m.
And
on
he's
Sunday.
not to be released until 5 p.m. on Sunday.
Understood. Thank you.
Is there, will you please ask that the defendant update his phone number with pretrial services? He's recently changed his number in jail calls.
Excuse me, have you, Mr. Handte?
No, I haven't.
Well, they need, you're on pretrial services, so they need to
I have the
reach you.
phone right here, Judge. If you want to call me on it right now, I'm more than happy to answer it.
So here's how this works. I'm not trying to make this more difficult. If you're on pretrial services, it's a standard requirement of them and the court that the pretrial service officer who's supervising you knows how to reach you by being able to call you directly. You don't have to state it on the record. What I am ordering you to do, though, when you walk out in the hall here in a few minutes, and I don't know if it's Mr. Meredith that's reporting to you, make sure he has your phone number.
He does, Your Honor. He's had it since day one.
Okay. We're good.
We're seeing 2 phones in front of us.
This is my primary phone, Judge. Mr. Stege alludes to the fact I've got 2 phones. Is that against the law, sir? I don't believe so.
As long as Mr. Meredith can reach you when he needs to.
And he has.
We're good.
Thank you.
Now, Ms. Reynolds, anything else that you'd like to say?
No,
All right, thank you very much, everyone. Appreciate your courtesy and professionalism during this hearing. The court will be in recess.
All rise.